Hello viewers, Namaskar. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. Today, we will discuss the topic changes in punishment. So, to begin with, different philosophers, criminologists, penologists, psychologists, they have all tried to present their own understanding as to what is the objective of punishment. Why do we need to have punishment in the first place? So for that, different people have had their own views, according to which we've got multiple theories regarding the purpose of punishment. Foremost, we have the deterrent theory of punishment, according to which the objective of punishment should be to deter. For them, punishment that is to be awarded to an accused should be exemplary. That should be so harsh that other like-minded or criminal-minded people would think twice before taking to a life of crime. So these are the people who advocate for death penalty or public flogging of people, or giving a punishment in an exemplary and a harsh manner so that it serves as a lesson, it serves as a deterrent to others also. The next theory of punishment is the retributive theory of punishment. For them, the theory is an eye for an eye and a tooth for a tooth. But we have to be mindful that an eye for an eye would leave the whole world blind. So, although this is a theory which is practiced in many Islamic countries wherein they believe in giving the kind of punishment which is exactly of the same kind as the damage that was done by the accused persons. But see, in modern progressive societies, these kind of punishments, they cannot have any place. And that is why we have different theories regarding punishment. Like one theory is the preventive theory of punishment. According to them, all those who are criminal-minded people or those who have that kind of a disposition that they would indulge in any kind of a crime, or those who are repeat offenders. So what needs to be done is, those people they need to be rounded off, and they need to be banished from their territory, or they need to be put behind the bars, or maybe there should be externment proceedings against them so that they are not allowed to commit a crime. For the preventive theory, prevention is better than cure. So they say that the state needs to identify those people who have already committed crimes and who are also capable of committing crimes in the future, and then those people, they need to be separated from the rest of the people so that they don't get an opportunity to disturb the peace and calm of the society. Then, the next theory is the reformative theory of punishment, something which a modern welfare state committed to the welfare of its people has to abide by. See, reformative theory, it is based on the premise that hate the sin, not the sinner. Everybody deserves a second chance. See, every saint has a past and every sinner has a future. So what we are supposed to do is, we are supposed to reform the offenders by, maybe once if they are punished for whatever they have done, we have to give them some sort of a vocational guidance. We have to train them. We need to tell them that what is wrong with the way of life that they were following and how they can have a better future, and then we need to provide them opportunities and guidance in order to reform themselves, so that once they are released from prisons, we can avoid recidivism. So that in a way we have to train them, guide them in a manner so that they don't go back to the life of crime which they were earlier involved in. So that is a reformative theory of punishment, something that India abides by. And then there is an expiatory theory. which means that we need to not only reform the offender, we also need to give those people an opportunity to cleanse themselves from within. That is, it is not only the body that needs to be punished, it is the soul also that has its own journey. So the soul also needs to understand that, see, what I have done is wrong and I need to repent, and I don't have to repeat these things, so that a person realizes, a person understands that what the person has done is wrong, and they try to undo the harm, they tries to minimize the impact of the harm that was inflicted by them, and they do not repeat those crimes in future. So these are different kinds of theories of punishments. In India, we go by a blend of the preventive and the reformative theory, and to an extent the deterrent theory also. So ours is a blend of all these theories. Basically, by and large, we abide by the reformative theory of punishment. So let us try and understand how punishments, they have been given under our laws. So what is a punishment under the Bharatiya Nyaya Sanhita 2023? So punishment is a means to secure compliance with the established laws of any country. See, laws, they lay down what is acceptable conduct, what is unacceptable conduct, and accordingly we have to regulate our behavior in a civilized society, so that we do not harm anyone else, and at the same time we have to ensure that our interests, our rights are also protected, and that is what the state does, and that is why the state lays down established norms, what is to be followed by people. Okay, so these are the established laws. Now, if a law was toothless, if there was no teeth, that is, if there was no punishment for a person who violated the law, then what would be the objective behind those laws? Especially when we are talking about criminal laws. See, crimes are public wrongs, wrongs against the public at large. So irrespective of the person who is harmed, the prosecution is always initiated by the state. And that is why the state has to expressly lay down that what would be the punishment for what kind of a crime. So punishments, when the state imposes punishments, when the state lays down laws, it imposes punishments with an objective of preventing the offences, and at the same time the objective is to protect the society. So modern penology, it provides for punishment of criminals by affixing their criminal liability, and at the same time imposing sentences on those who commit any wrongs. And how do we arrive at the exact sentence that is to be given to a person? That is on the basis of gravity of offences. So higher the gravity of the crime that is committed by a person, more the punishment that his crime would entail. So the offences which are of a severe nature, they attract higher punishments as compared to those offences which are of a lighter nature. So sections 4 to section 13 that are contained in chapter 2 of the Bharatiya Nyaya Sanhita, it deals with punishments. So it explains the nature of different kinds of punishments that are awardable under various provisions of the Bharatiya Nyaya Sanhita, how punishments are enhanced, how these punishments can be commuted, and how fractions of terms of punishments they are to be calculated. So, what are the various kinds of punishments to which offenders they could be liable under the provisions of this Sanhita? Section 4 of the Bharatiya Nyaya Sanhita 2023 lays down the various kinds of punishments. The highest punishment that is provided under our substantive criminal law is that of death. After that we have imprisonment for life. Now imprisonment for life is also now, after 2013, we have witnessed a trend wherein the courts, they used to categorically mention that the accused is to be awarded imprisonment for life, which shall mean the remainder of that person's natural life. So does that mean that if we simply say imprisonment for life, that doesn't mean imprisonment for the remainder of that person's natural life? No. Imprisonment for life means imprisonment for the remainder of that person's natural life, but when the legislature in its legislative wisdom qualifies this as the accused shall be awarded imprisonment for life, which shall mean the remainder of that person's natural life, what are we doing in this? In this, we are taking away the power of the state to, in a way, commute the sentence. See, otherwise we have prison manuals under which imprisonment for life is ordinarily commuted when an accused has already spent 14 years in the prison. But when we have specified that it is imprisonment for the remainder of that person's natural life, then in such cases the Home Department cannot do so. Of course, this will not have any bearing whatsoever on the executive power of clemency, which vests exclusively in the state. Then the third kind of punishment is imprisonment. See, imprisonment means a person is to be deprived of a person's personal liberty and put behind the bars. So, when we are sentencing a person to imprisonment, we need to specify what kind of imprisonment is the accused being sentenced to. Is it rigorous imprisonment or is it simple imprisonment? So, viewers, let me clear here that whenever we talk about imprisonment for life, see, that is a serious kind of an imprisonment. So, that ordinarily implies rigorous imprisonment, and when we talk about simple imprisonment, that means that the accused is not supposed to do any hard labor or any kind of work when the accused is in the prison. It is his wish. If he wants, he can do maybe some gardening, so he can help with the cooking or cleaning, but then again there is no hard labor as it is that is involved in that rigorous as is involved in the rigorous imprisonment. In simple imprisonment, there would be some simple jobs that a person might want to do. See, and then when we talk about rigorous, that is again, that cannot be very objective, that see, these people, they have to be sent to construct roads or break boulders or any such thing. That depends upon the capacity of a person. Suppose there is a fragile woman, suppose there is an old man. So, in such cases, hard labor would not be the same as could be given to an able-bodied young man. Okay. So, punishment could be either rigorous or simple depending upon the facts and circumstances of each and every case, and even in cases where rigorous imprisonment has been awarded, in those cases also that would depend upon the kind of work that would be awarded to the convict within the prisons. Then the next kind of punishment is forfeiture of property, then there is fine, and then there is community service. So, forfeiture of property, when we talk about it, see, now we do not have absolute forfeiture of property, but forfeiture of property is a kind of punishment in which the state takes away the property, no compensation as it is given to the accused person. Why? Because see, ordinarily what happens when the state suppose acquires some properties for any construction work or any other development work, in such cases, if the state takes away the property of an individual, of a private person, the state usually compensates that individual with some sort of a money or some alternate property. But when it is as a measure of punishment, that is when somebody's property is to be forfeited by the state, then this is a kind of punishment for which no compensation whatsoever is to be awarded to the accused person. Further, what happens in forfeiture of property? Because the property is taken away, so what are the kind of people who are subjected to this kind of a punishment? Usually smugglers, black marketeers, or people whether they are in government service or wherever, but if they have amassed assets that are grossly disproportionate to their known sources of income, then in such cases their property can be forfeited by the state. Then there is fine. See, fine is usually it is imposed on a person, and it could be along with imprisonment, and sometimes there are certain petty offences for which it is only fine that is a kind of punishment. So, fine can be imposed either with or without imprisonment, and then there is community service, which is a new and a progressive kind of punishment. It is a way that in which we have tried to bring in some elements of restorative justice within our criminal justice system. So, let us first talk about death penalty. So, death penalty or capital punishment, it is the highest penalty that is awardable to an accused under the Bharatiya Nyaya Sanhita. In India, death penalty is executed by hanging till death. So, a person is to be hanged till death. Then, see, courts have been granted a great deal of discretion in the award of death penalty. So, death, it is not to be awarded except in extremely severe cases where murders have been committed in cold-blooded, pre-planned or barbaric fashion. So, you see, although our courts, they enjoy a great deal of discretion in awarding death penalty, but still it is something which is not to be awarded except where murders, they have been committed in a cold-blooded fashion. See, because in such cases what would happen? If we were to allow criminals who were guilty of having committed intentional, deliberate, cold-blooded and brutal murders, if such people, they were allowed to escape with a lesser punishment, then that will deprive the law of its effectiveness, and this would result in a travesty of justice. Then, whenever death penalty is awarded by the court, it needs to be confirmed. Because see, at the initial stage, death penalty is to be awarded by the trial court, which would be a sessions divisions court. Now, the death penalty that is to be awarded, it is not to be executed till the time the death penalty is confirmed by the High Court. Now, why is this important? Because see, Article 21 of the Constitution of the India, what does it guarantee? No one to be deprived of his life or right of personal liberty except according to the procedure established by law. So, that is why what is at stake here when somebody's life, when somebody's personal liberty is at stake, and when we are talking about death penalty, it is the life that is to be taken away by the state. So, no one to be deprived of right to life or personal liberty except in accordance with the procedure established by law, and the procedure has to be established in a transparent manner with effective checks at every point so as to ensure that injustice doesn't take place. If a person is to be deprived of his life, a person who is to be awarded the death penalty, so there is this minimum check that has to be exercised on this punishment before it is executed. And what is the check? That a death penalty which has been awarded by the sessions court, it has to be necessarily confirmed by the concerned High Court, only then it can be executed. So, this is a prerequisite. Sections 407 to sections 412 of the Bharatiya Nagarik Suraksha Sanhita lay down rules for submission of death sentence for confirmation. So, sections 453 to 456 of the Bharatiya Nagarik Suraksha Sanhita lay down provisions in respect of execution, suspension, postponement, remission and commutation of death sentence. So, you see, we have detailed laws regarding all the aspects of death penalty, even if we need to execute it, even if it needs to be suspended for some time, if it needs to be postponed, if it needs to be, if there has to be a remission in the respect of that, even if it has to be commuted. So, that is all to be done accordance with the procedure that has been established by the law. So, first let us talk about execution of order that is passed under section 409. So, under section 453 of the Bharatiya Nagarik Suraksha Sanhita, when in a case submitted to the High Court for the confirmation of a sentence of death, the Court of Session receives the order of confirmation or other order of the High Court thereon, it shall cause such order to be carried into effect by issuing a warrant or taking such other steps as may be necessary. Then, how is a sentence of death that has been passed by the High Court, how is it to be executed? So, under section 454 of the Bharatiya Nagarik Suraksha Sanhita, when a sentence of death is passed by the High Court in appeal or in revision, the High Court of Session shall, on receiving the order of the High Court, cause the sentence to be carried into effect by issuing a warrant. Then, what is the provision related to postponement of execution of sentence of death in case of appeal to Supreme Court? See, once the penalty has been confirmed by the High Court, still there is another authority, and that is the Supreme Court. Suppose the accused wants to go in appeal against the decision of the High Court. So, then what is to be done? Under section 455 of the Bharatiya Nagarik Suraksha Sanhita, where a person is sentenced to death by the High Court and an appeal from its judgment lies to the Supreme Court under subsection A or subclause B of clause 1 of article 134 of the Constitution, the High Court shall order the execution of the sentence to be postponed until the period allowed for preferring such appeal has expired, or if an appeal is preferred within that period, until such appeal is disposed of. Further, where a sentence of death is passed or confirmed by the High Court and the person sentenced makes an application to the High Court for the grant of a certificate under article 132 or under subclause C of clause 1 of article 134 of the Constitution, that is when a person is seeking permission, then the High Court shall order the execution of the sentence to be postponed until such application is disposed of by the High Court, or if a certificate is granted on such application until the period allowed for preferring an appeal to the Supreme Court on such certificate has expired. Where a sentence of death is passed or confirmed by the High Court and the High Court is satisfied that the person sentenced intends to present a petition to the Supreme Court for the grant of special leave to appeal under article 136 of the Constitution, the High Court shall order the execution of the sentence to be postponed for such period as it considers sufficient to enable him to present such petition. Now, how do you commute the sentence of death on a pregnant woman? So, let us talk about the provision related to commutation of sentence of death when a woman is carrying a child. So, under section 456 of the Bharatiya Nagarik Suraksha Sanhita, if a woman sentenced to death is found to be pregnant, the High Court shall commute the sentence to imprisonment for life. So, this is a mandatory provision. So, if a woman, she is pregnant at the time when she is sentenced to death, so then the death sentence, it cannot be executed on the woman and the sentence would be commuted to imprisonment for life, and the reason is because a mother, a woman who is on the way to motherhood, she is expecting a child. Now, if she is hanged till death, the child that is in its mother's womb would also be sentenced to death. Even if we were to postpone the execution of sentence till the time the woman delivers the baby, even in such cases it would be an extreme punishment for the child to grow up without its mother. So, that is why what the law says is that in such cases the High Court shall commute the sentence to imprisonment for life. Bharatiya Nyaya Sanhita lays down a list of offences for which death penalty may be awarded under the law. So, what are all those offences? Let us talk about them. I have compiled all those offences in one place. Let us talk about them. First is punishment for rape that causes death or results in persistent vegetative state of victim. Section 66 of the BNS. So, viewers, as you all know that rape is a very heinous crime, and a rape which is committed in a manner that the woman either dies or she is rendered in a persistent vegetative state. So, in such cases the accused deserves nothing but the extreme penalty of death. Then, in cases of gang rape, then Punishment for repeat offenders that are guilty of rape. A person has been convicted of rape and then the person again repeats this kind of a heinous crime, then in such cases death penalty may be awarded. See, again we have to be careful that in all these crimes death has been prescribed as a kind of punishment. Death penalty is not to be mandatorily awarded. See, the law prescribes that this is the maximum sentence and thereafter there is a discretion with the courts to decide depending upon the gravity of the crime and so many other considerations that are to be kept in mind before deciding that although there is a discretion to award death penalty, but whether such a discretion is to be exercised against the accused person. So, you see, in cases of rapes, repeat offenders of rapes, in cases of what we call as gang rapes, so death penalty is there. It is an option which is available to the judges. Thereafter, in cases of murders, then suppose there is a murder which is punished, which has been committed by someone who is already a life convict, someone who has already been sentenced to imprisonment for life and such a person commits another murder, then death penalty is an option there. Then see, mandatory death penalty was there, but it was struck down by the Supreme Court in Mittu versus State of Punjab in 1983 as being unconstitutional and void. See, then abetment of suicide of a minor, insane or person who is intoxicated, or attempt to murder by a person under sentence of imprisonment for life if hurt is caused. In case of terrorists act, and if there is kidnapping or abduction that is done in order to murder or for ransom. Then if there is waging or attempting to wage war or abetting waging of war against the government of India, abetting mutiny that is actually committed, giving or fabricating false evidence upon which an innocent person suffers death, and in cases when dacoity is accompanied with death. In all these cases death penalty may be awarded. So viewers, that will be all for this lecture. In the next session, we will further continue with the various kinds of punishments that have been prescribed under the BNS and what are the cases wherein they can be awarded. Thank you.